This is Conversations in Civics. I'm Dr. Terry Susan Fine. With me now is Greg Sherman, a civics teacher at Conway Middle School in Orlando. Greg, you have the quote, "Failure is not an option," on your teacher webpage. Could you help us understand how that applies to civics and why you decided to put that quote on your teacher webpage?
You know, Dr. Fine, I am just a firm believer that all students need to be successful and can be successful, and we can help them be successful. So that's why I have that. It's a bumper sticker I got from Kennedy Space Center. It goes with Apollo 13, and it's there every day they come in the classroom. It's there. It's on my web page as well. And I just want them to know that, we'll do whatever it takes to get them, to be successful and pass, and don't give up and don't beat themselves up. And I think it's a great motto for our country as well. I mean, through our history.
Thanks for the clarification on that quote. Let's get started. For this conversation, we want to compare Florida's Constitution with the United States Constitution. With that, what's the first question that comes to mind for you?
If the U.S. Constitution is the supreme law of the land, then why have a Florida Constitution?
Well, because Article 4 of the U.S. Constitution says that every state shall have a Republican, small r, it's not partisan document, shall have a Republican form of government. And so the Florida Constitution sets up the structure of that government. Article 4 only says that there'll be a representative form of government, but it doesn't say what that will look like. So there needs to be a rule of law that is particular to Florida. And so yes, because the U.S. Constitution is the supreme law of the land, the Florida Constitution can't contradict it. But at the same time, there still has to be a set of branches of government, agencies. What will the branches of government do? How will people be elected? When will elections be held? What will those positions be called? And so forth. So it is very important to have a state-level constitution.
Absolutely. And also how long a person will be in office once they're elected
as
well, too. What's the big differences between the U.S. Constitution and the Florida Constitution?
I would have to say, Greg, that there are probably three big differences between the two documents. One is that one of them is much older than the other, right? The Florida Constitution, the one that we have right now, was actually ratified in 1968. So it's actually a relatively recent constitution, and it's the sixth constitution for the state of Florida. The U.S. Constitution, there's been one constitution amended several times, but there's only been one, and Florida has had six. So one of the key differences is sort of when those constitutions were ratified and sort of what that means. The second big difference that we see is the amendment process, is the way that the constitutions can be amended. At the federal level, the way that we amend the Constitution is that the state legislatures, along with the U.S. Congress, they vote on whether or not there shall be a change or an amendment to the Constitution. Now, the federal Constitution says that either the Congress can start the process or a convention of the state legislatures can start the process. But to be honest with you, Greg, that second one has never been used. Still an option. Failure is not an option, but it is an option to start the amendment process at the state level. It's just never happened. The U.S. Congress, 2/3 of each house of the U.S. Congress has to say yes to an amendment. Then, traditionally, it has gone to the state legislatures, and then 3/4 of the state legislatures have to say yes. Now, the U.S. Constitution has been amended 27 times. One of those 27 has reversed the other one, and that was prohibition of alcohol. The first 10 were added together in 1791. We call those the Bill of Rights. So when we really look at, sort of from 1791 up until today, the last one being 1992, and you say, well, there's about 17 changes if we look at the Bill of Rights as sort of a whole group of amendments. So that was one set of changes, and then sort of 17 more since then, and then of those 17 more, one reverses the other. So the process is very different, and it's different not only because the citizens, they have an indirect role but not a direct role. The citizens elect their state legislatures, and they also elect their national legislative representatives. But also another big difference is that or really not a difference, but an assumption is that not only do the citizens not play a role, but the president doesn't get a vote either. Now, all too often when we look at presidential campaigns, how many times does a presidential candidate say, I believe in an amendment to the U.S. Constitution and I support it if it does X? Well, that's nice, but he doesn't get a vote, okay? We might assume he gets a vote based on that advertising, but he doesn't get a vote. Now, let's look at Florida's Constitution in terms of the amendment process. The way that we amend the Florida Constitution is the citizens vote on an amendment after it's been through a process of placing that amendment on the ballot. Now, that process could be a set of petitions. I think right now it's over 600,000 or so. You have to get signatures of registered voters in order to petition. And that petition then is reflected on the amendment ballot, and then the citizens vote. Or it could be something that's put on the ballot by the state legislature. It could be put on by the Constitutional Revision Commission that meets once every 20 years. So there's sort of different methods in place. And then the Florida Supreme Court has to make sure that it deals with only one issue and that the language is clear and understandable. Now, of course, we could have a discussion about what's clear and understandable, but nonetheless, they make that determination. So with that in mind, ultimately the citizens decide. Right now, there has to be at least a support of 60% or more, which was in the Constitution as 50%, and then the citizens, through an amendment, changed the amendment process so that now you need 60% or more. So that's sort of a second key difference, is the amendment process. The third key difference, at least since you're asking me my opinion, is the way that the court system is made up, okay? At the federal level, for federal and for Supreme Court justices, they serve for life with good behavior. And the idea is that then depoliticizes the process. It sort of takes the politics out if you're there for life with good behavior. However, at the state level, our state Supreme Court, it's an interesting process. You're nominated and then confirmed by the Senate. You're nominated by the governor and then confirmed by the state Senate. But then you have to go for something that's called retention, which means that every 7 years, your name goes before the voters should this person be retained as a justice of the Supreme Court. So you're not getting elected, but certainly you can lose your seat on the court through this process. So there's some politics involved, because if you believe that your seat is threatened, you might have to go on TV and say something. There's a lot of laws that say you can't talk about how you would rule on a case. You can't say I'm pro this or anti that. So you have to sort of talk about why it's a good system in place and whatever else. At the same time, interestingly enough, not only do you not serve for life with good behavior because of that 7-year issue, but did you know, Greg, that there is a mandatory retirement age for members of the Florida Supreme Court?
That's 70 years old.
70? The state with the highest percentage of senior citizens in the nation has a relatively youthful retirement age. I mean, we had, if you look at the U.S. Supreme Court, William Rehnquist was 91. John Paul Stevens was 91 when they left the court. 70? Think about it. If we had life with good behavior, people could readily serve into their 90s, as we've had our most recent justices who left. 2 of the most recent justices leaving were in their 90s when they left. So that, to me, are sort of the 3 big differences, because the court system then might have some politics involved in terms of who gets nominated. If they have to leave when they're 70, that might mean that someone who's perhaps very well qualified, but they're, as old as 60. Senior citizen. If they're 60, then they might not get nominated. But a 60-year-old, Ruth Bader Ginsburg, for example, she was 60 when she was nominated by Bill Clinton. So there are some politics involved just because of those procedures. We see the amendment process is very different, and we also see that sort of when the Constitution that we're living under was originally ratified is also very different.
Right.
So those are three differences.
How about the number of Supreme Court justices? I know in the federal level we have 9. In the state level there's 7.
Yes and no. The Article 3 of the U.S. Constitution doesn't give a set number, so it doesn't have to be 9. And in fact, we know that Franklin Roosevelt tried to change that in the 1930s. But yes, it is set at 7. So it's an odd number either way, and that avoids ties.
Right.
Yeah. The other, I mean, I thank you for bringing that up. The other thing is that the Chief Justice is rotating on the Florida Supreme Court, but on the federal Supreme Court, the president nominates and the Senate has to confirm who the Chief Justice is, and that person can serve for life with good behavior.
Right. How about similarities between the two documents, the U.S. Constitution and the Florida Constitution? I know we have the 3 branches of government in both federal and state.
Well, both of them, not only do they have 3 branches of government, but they also each have their own Bill of Rights. But one way that they're different is that the Florida Bill of Rights actually includes a right to privacy, but the federal Constitution only includes a right to privacy because the Supreme Court said there was one in 1965. But that was based on interpreting certain rights that are articulated in the U.S. Bill of Rights. So the right to privacy is actually stated in the federal Constitution. It is not stated, but it is sort of presumed through a series of multiple amendments being taken together, being given a right to privacy. You know, Greg, I've been thinking through this fascinating conversation about the legislatures and how the constitutions are different in terms of the legislatures. And would it be all right with you if I sort of talked about that for a minute or two?
Absolutely.
At the federal level, there are no term limits for members of the legislature. So members of the House of Representatives, they serve for 2-year terms. They go up for election every 2 years, and they could serve for many, many decades, okay? Because you can be 25, and if you live till your 90s, you could serve a very, very long time. At the state level, there used to be unlimited terms, and through a citizen decision, because it was an amendment, we now have something called term limits. And the term limits are 8 years, no more than 8 years in the House, no more than 8 years in the Senate. But since the House in Florida, federal too, is a 2-year term, the Senate in Florida, it's a 4-year term. Federal is 6, okay? Because it's a 4-year term, so that means it's 4 2-year terms plus 2 4-year terms. And that together adds to 16, but 8 in each house. And that's a lifetime limit. So that means that no matter if you sort of serve in the House, then in the Senate, go back to the House, it doesn't matter. It's a lifetime limit. And that movement was called the 8 is Enough movement. Some of us may remember from our childhood a show called 8 is Enough, and so we could sort of relate to that title. But indeed, the idea was, you can serve, you're in there a long enough time so that other people can come into the process because we know that the power of incumbency is so meaningful when it comes to getting reelected. In fact, there are people who study this, and they say that political party is actually less important than incumbency in terms of sort of why people vote for who they vote for. But interestingly enough, in 1992, when this change was made, the citizens in Florida also said that there was going to be a change at the federal level, that not only was it 8 years at the state level, but also 8 years at the federal level for members of the House, and then 2 6-year terms for the U.S. senators. And you think, isn't that the power of self-determination that Floridians say, 8 years for my members of Congress, or 12 if they're in the Senate? And it voted. It was a clear majority, well over 50%. And wouldn't you know, the United States Supreme Court said that that would have the impact of amending the federal Constitution, because the federal says no term limits. So as we were talking when we started this conversation about a key difference in the amendment process, well, if it's up to Congress to decide to term limit itself, guess what will never happen? Congress will not term limit itself. So Floridians could not decide to term limit members of Congress through this amendment to the Florida Constitution. So now we have this interesting system where we have term limits at the state level, but at the federal level, in the legislators representing Florida, they are folks who can be there forever because there are no term limits at the federal level. And because it's Congress, ultimately 2/3 of each house that has to make that decision, you know, we could bet a lot of money and know that it would never happen, right? We would keep our money if we bet that it would happen, because it's never going to happen. Greg, it's been such a pleasure talking about these issues with you. We see when we look at Florida and the U.S. constitutions, even though they're both constitutions and one constitution emerged from the other, that they're very similar, but they're also very different, and they're also very different in terms of how they're changed. We've been comparing Florida's Constitution with the United States Constitution today. That's Conversations in Civics. I'm Dr. Terry Susan Fine.